a pretrial conference. And Mr. McQuarrie, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, you know, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Okay, Mr. McQuarrie, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court matter?
Before we jump back into the courtroom, let's rewind for a second, because this is not just another routine hearing. This is a continuation of a sovereign citizen saga that's been building across multiple appearances. And this time, Cornell McCrary is walking straight into the courtroom of Judge Bryant, one of the strictest, no-nonsense judges on this. If you've watched sovereign citizen cases before, you already know the playbook: the all-lowercase name argument, claims of corporate entities, emotional accusations of bias, and a total refusal to follow courtroom procedure. But here's the thing, Judge Bryant doesn't entertain games. She runs her courtroom with precision, and she expects defendants, especially those representing themselves, to follow the rules like real attorneys. Starts as a simple pre-trial conference, quickly turns into a clash between internet law myths and real-world legal authority. We're about to see Cornell attempt to derail the proceedings with accusations, motions, and emotional appeals, only to be met with firm control from the trust me. This hearing reveals exactly why trying to outsmart the court.
To file a motion with the court, I can give you a motion hearing date, but otherwise I want to know, as it relates to this pretrial conference where you've indicated that you want to represent yourself, it is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court, with all due respect.
You're going to be restrained every time you go off course. So
well,
understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCrary, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias. And once this motion
is denied, anything.
And there it is, one of the most classic sovereign citizen arguments right out of the gate. Cornell insists his name in all lowercase is somehow different from the all caps corporate entity the court is supposedly prosecuting. This theory floats around online, claiming that courts only have authority over a fictional business version of your name, not the living PE reality. This argument has been rejected in courtrooms thousands of times. The way your name is typed has zero impact on jurisdiction, identity, or responsibility under the law. But sovereign citizens cling to it like a legal loophole that somehow invalidates every charge against us. Interesting is how confidently Cornell delivers it, as if simply correcting capitalization should stop the entire case. And you noticed how these arguments always sound complicated but never actually hold up when
as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCrary, and ask him how does he wish to proceed with the hearing for Mr. McCrary.
Yes, Your Honor.
Violation code of judicial conduct, Judge. And I haven't been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McCrary, I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule, man.
Okay, thank you, Mr. McCrary. Thank you, Mr. McCrary.
Yes, ma'am.
Your Honor?
Yes, sir.
They indicated that he would need to file a motion for recusal before you, and if you deny that, it then goes to the chief judge.
He already
Well,
did. I accepted his oral motion. I denied it. So tell them it's denied.
This moment perfectly shows the difference between emotional arguments and legal procedure. Cornell tries to frame the situation as a violation of his First Amendment rights, saying he felt disrespected and restrained. But Judge Bryant immediately redirects the focus back to the purpose of court, handling legal matters, not personal art therapy sessions. They're structured environments where cases move forward based on rules, evidence, and procedure. And when you represent yourself, the burden is even higher. You're expected to follow the same standards as a licensed AE. Bryant makes it clear, today is about the pre-trial conference, not side speeches or personal grievances. And from this point forward, she repeatedly RS Cornell back in every time he drifts off. CE is where you can already tell, this judge is not going to let the courtroom turn into a stage for sovereign citizen theatrics.
I'm not requiring him to file a written motion. The court rules don't require a written motion. He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McQuarrie, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay.
Who do my call? The clerk? What is no?
Sir, if you just, I promise you, I've been on the bench for 16 years, and I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
Here comes the next tactic, accusing the judge of bias and filing a motion for recusal. Sovereign citizens often use this when they realize the judge isn't playing along with their arguments. The hope is either to delay proceedings or get a different judge who might be more. In Michigan, as the narrator explains, a defendant can request a judge's disqualification. But there has to be a real legal reason, not just disagreement with rulings or tone. Judges deny these motions all the time when there's no evidence of actual notice how quickly Cornell jumps to this move. He hasn't even gotten into the substance of his case yet, but already wants the judge RS, a classic stall tactic. But Judge Bryant knows exactly how the process works and handles it efficiently.
Just say this, Judge, I have nothing personal with you. It's just that
I don't take things personally. Ms. McQuarrie, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say that this case is from 2002. And maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However,
this exchange really highlights Judge Bryant's experience. She calmly walks through the proper legal process, explains that she accepted Cornell's oral motion, denied it, and will forward it to the chief judge, exactly as the rules s. No drama, no emotional reaction, just procedure. That's what real courtroom control looks like. While Cornell seems confused and eager to jump in with more commentary, the judge keeps things moving forward in an orderly. Can also hear a bit of frustration creeping in, not anger, but the exhaustion of someone who's handled countless self-represented defendants who don't lie. Is the system working exactly as designed, even when someone tries to disrupt it?
Asked me to recuse myself. I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McQuarrie, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
Now we get an important revelation. This case dates all the way back to 2002. That's over 2 decades old. And Judge Bryant hints that if Cornell had simply followed normal procedure, possibly accepted legal counsel, this matter could likely have been resolved quickly, maybe even, he chose the sovereign citizen R. Let's rewind for a second, because this is not just another routine hearing. This is a continuation of a sovereign citizen saga that's been building across multiple appearances. And this time, Cornell McQuarrie is walking straight into the courtroom of Judge Bryant, one of the strictest, no-nonsense judges on this. If you've watched sovereign citizen cases before, you already know the playbook: the all-lowercase name argument, claims of corporate entities, emotional accusations of bias, and a total refusal to follow courtroom procedure. But here's the thing, Judge Bryant doesn't entertain games. She runs her courtroom with precision, and she expects defendants, especially those representing themselves, to follow the rules like real attorneys. Starts as a simple pretrial conference, quickly turns into a clash between internet law myths and real-world legal authority. We're about to see Cornell attempt to derail the proceedings with accusations, motions, and emotional appeals, only to be met with firm control from the "trust me,